Tactical Guy 1 here from the YouTube world. I want to share this information with you guys, but I need to start off by saying I am not an attorney and this is not legal advice. This is for entertainment purposes only. This is called a demand probable cause determination, Penal Code 991 motion, and when it's appropriate. It states consider making motion for probable cause hearing, i.e., Penal Code 991 motion, when you want the court to make an independent judicial determination of whether there is probable cause to believe that a public offense has been committed, defendant is guilty of that offense, and you're in custody at the time of arraignment. In other words, defendant is in custody at the time of arraignment. In other words, let's just say I'm charged with a DUI and it's Tuesday, and I come back and on Wednesday I can make bail. Personally, I will not make bail so that on, say, Thursday, if it's arraignment or my probable cause hearing day, then I simply can say, Your Honor, I move to dismiss the complaint. I move the court to provide me a probable cause hearing. And they'll say, oh, okay, crap. Versus bail, making bail on Tuesday, and now I can't do that for, or say on Wednesday, and I can't do that for Thursday. So either way, I would rather be in custody. In other words, that's what I would rather do. Yes, it's hard. Yes, it's a headache. You might have to go to work, but guess what? 9 times out of 10, if you're innocent and they don't have sufficient evidence, it can actually make this case go away a lot faster than having to fight it for a whole year and then be found not guilty, or maybe even have the prosecutor finally dismiss the charges. It just saves a lot more time. Okay, it goes on to say here, before you move, review leading cases. In Re Walters, that one says recognizing that misdemeanor defendant has right to probable cause hearing. People versus Ward. It states applying Penal Code 991 procedures. Gerstein versus Pugh. Original federal case recognizing constitutional right to speedy probable cause determination. County of Riverside versus McLaughlin. That one's interpreting Gerstein versus Pugh Supra to require a probable cause hearing within 48 hours of arrest. Judge's perspective. Be aware that the court may have held a McLaughlin probable cause hearing, see County of Riverside versus McLaughlin Supra, before the arraignment. Example, if 48 hours falls on weekend or holiday. Usually that happens when you go in front of the judge and they don't talk about anything. They don't ask you to plead guilty, not guilty. You were in jail and they rush you out to the court, and all of a sudden you're rushed back and you don't realize it. But this is the kind of information that one needs, and if they don't know they need it, they're pretty much screwed. So it really is a catch-22. This is why I thought this was a very important video to make. And it says when to move. Make a motion to determine probable cause, Penal Code 991, A, at the arraignment, B, after client has pleaded not guilty, if earlier McLaughlin hearing, in other words, if it was before your arraignment, if the court held a McLaughlin probable cause hearing before the arraignment, and before client was represented, see judge's perspective above. In other words, you're screwed. So this is why, folks, you guys need to know this information in case if you're ever stuck in jail and they send you in front of the judge, now you have an idea of what they're doing, even though they're not telling you what's going on. You may want to make a Penal Code 991 motion at the arraignment in order to make sure the court determines probable cause on the basis of the proper evidence, see below. But B, expect prosecutor to argue, and court may agree, that you are not entitled to a second review of probable cause. In other words, if you had one already prior to arraignment, because usually they a probable cause determination or hearing coincides with your arraignment. But if that happens to be, if you're arrested and it's on a holiday or a weekend, then the 48 hours is going to be before, the, say, second day. So it'll be maybe on Monday and not Tuesday if you're arrested on Sunday or Saturday. So just keep that in mind. If you go in front of the judge and nothing happens and they whisk you back, then 9 times out of 10 that was your probable cause hearing. Okay, how to move. Orally ask the court to dismiss the complaint. Evidence court considers. This is what they're going to consider. Prosecutor must provide to the court documents required by Penal Code 991C, including arrest warrant with supporting affidavits, which usually it's non-existent. B, sworn complaint with documents and reports that are incorporated by reference, or other similarly reliable documents. Note, if you are having problems obtaining police reports and related discovery, use a Penal Code 991 motion. If complete evidence not provided, now this goes on to say, like, let's just say, for example, they don't want to provide all the evidence. There's a police report somewhere, and they don't want to provide that, or whatever the case may be. It says if prosecutor does not provide the proper supporting affidavits and incorporated documents, the court should grant your Penal Code 991 motion and dismiss for lack of probable cause. Now, 9 times out of 10, they won't even have it, because if you're innocent, how are they going to make it? They can't. Defendant entitled to immediate ruling. Court must immediately determine whether there is probable cause unless it grants defense request for continuance of not more than 3 court days on the basis of a showing of good cause. Example, to investigate the information provided by the prosecutor. So let's say I need more time. Your Honor, I move for continuance of not more than 3 days so that I can review whatever evidence the prosecutor has. And that way I can orally argue a lot better. That's just an example. Or I can just simply say screw it, not ask for that, and just see what the judge says. Note, you have the right to request this continuance. It is not the prosecutor's right or for the judge's convenience. See In re Walters. So in case they want to start saying, oh, well, we don't have time, or oh, you can't do that, that's for me. The judge wants to get belligerent. Objection, Your Honor. In re Walters, 1975. That'll shut him up real quick, or shut her up real quick. Effective motion. If court grants motion, court dismisses the complaint and discharges the defendant. Penal Code 991D. And prosecution may refile the dismissed complaint within 15 days. Penal Code 991E. If court denies motion, you enter a not guilty plea. Penal Code 991D. And court sets the matter for trial. Penal Code 991D. Now, there was a case where I asked the judge, Your Honor, I move the court to dismiss the complaint and provide a probable cause hearing, and this was out of my arraignment. And at the time, I didn't know this because it wasn't a holiday and it wasn't a weekend, but I wasn't arrested on a weekend or holiday. So the judge actually told me, well, this is your probable cause hearing. I find that I find that there's sufficient evidence, so we're moving forward. That's it. I was like, okay, Your Honor, for the record, I object, and that was it. Um, I tell people I'd rather over object than under object. At least that way, if I ever have to appeal, the Court of Appeals can say, well, defendant objected here, 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 and there, instead of saying, oh, defendant never objected, therefore he acquiesced. But that's just my way of thinking there. Um, Also, there was a case where uh, a 991 motion was filed, and what was it? Also, a demur was filed, and the prosecutor dismissed the charges before the judge could rule on it, and then came back and amended the complaint. And so another demur had to be filed again, because now this is a whole different case. In other words, a whole different charge. So that's one trick they'll do too. For example, say, okay, well, we'll dismiss. They'll amend the complaint, and you think they're refiling the same charges, and they're not. It's something different. But people don't read what the charges are, so they don't know. So keep that in mind as well. I hope this video did help you guys. I mean, if it does help you eventually in the future, that's great. That's the whole purpose of these videos. And I only hope that you guys can please share this information with other people on your Facebook, Twitter, Google Plus, whatever you guys can do. I was gonna make a website, put all this information up there for pretty much eventually every state, but I have not received any donations, and because of that, I think what I'm going to do is just simply share this information on YouTube like I've been doing in the past, and I think that'll probably be the best way of doing that. So thanks for watching, guys, and hopefully you guys enjoy this video and you never have to use this information, but if you do, now you know. Godspeed.